He's gone. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. You seated?
Good afternoon and welcome to the Court of Appeals. Your panel this afternoon, to my right is Judge John Arrowwood. To my left is Judge Toby Hampson. I am John Tyson, and we'll be your panel for this argument. We have multiple cases on the document. This panel has one case, Howze versus Treyburn Rehabilitation. I may have mispronounced that. If I did, I apologize. But are there any preliminary matters before we get started? Me, the party? Okay. All right. Well, if there are no preliminary matters, we will hear from the appellant. Good afternoon.
Good afternoon.
And you may remove your mask.
May it please the court, my name is Caitlin Fudge and I represent the plaintiff appellant, the estate of Palestine Howze. I will be referring to the plaintiff appellant as plaintiff and the defendant appellees as defendants for simplicity, and I plan to reserve 7 minutes of my time for rebuttal. Palestine Howze was a patient of Treyburn Rehab facility on April 14th, 2020. She died from a treatable infection while at Treyburn. On that day, she could have brought a wrongful death claim against the defendants, but almost 1 month later, in May of 2020, the COVID-19 Recovery Act became the law of the state of North Carolina, and that law applied retroactively to the Howze estate's wrongful death claim. Because the immunity law retroactively impairs the estate's vested claim, it is unconstitutional as applied.
Now, where did you raise that in your pleadings or in your argument to the court?
We did not raise the constitutional challenge in our pleadings, but it was raised first in a response brief to the defendant's motion to dismiss, and we argued it for a significant amount of time in front of the trial court. And again, this is an as-applied challenge. It is not a facial challenge.
How are we to distinguish, I guess, between the two? You know, where's the dividing line between an as-applied challenge that may impact many other, or certainly some other potential plaintiffs, and a facial challenge which would apply even more broadly? Where do we draw that line?
Well, you have to look at the relief that we're seeking first. We are only asking for a constitutional ruling as applied here. We know that this.
But if we rule as you suggest, doesn't that, under our in re civil penalties cases, doesn't that apply to other cases in this situation?
Your ruling would apply to those who also have a vested claim during that retroactive period.
And so
However,
why does that not make it more than just an as-applied argument then?
Your Honor, it's because if you look at the provision of the statute that had the retroactive impact, it does more than just say this is all retroactive. What it does is it says, and I'll just briefly read from the statute, but it says that it applies since the governor's executive order number 116, which came into effect March 10th, 2020, or to all subsequent periods of time where a state of emergency is declared during the pandemic. So if you look at it, there are applications for those who have prospective claims that aren't raised by the constitutional arguments we have. So you wouldn't be able to strike the statute on its face. And there are two similar rulings I'd like to draw this court's attention to, both from one very recent. I think it was argued yesterday before you, Judge Tyson, the Cryon case. And there, the court acknowledged that the trial judge could not impute a facial challenge to a party that wasn't making it. We are not making a facial challenge. We're only arguing that it is as applied unconstitutional here. And you have to look at the facts of this case to even see the constitutional issue because of the fact that the statute applies to prospective claims as well. A similar case.
But my concern is that it wouldn't just apply. If yours was the only case out there, then I agree with you, it's just as applied, but it applies broader than to just your case. Our ruling, or there's a potential our ruling will apply to broader than just your case. I think, and so that's how I'm trying to understand how it's not broader than just as applied.
Yes, Your Honor, and I can answer that question. There's another case decided by this court last year, Emmy versus TJ, that looked at a similar concern that you have. That case dealt with a challenge to the statute that allowed for domestic violence protective orders. There, the order was denied to a woman on the basis of her being in a same-sex relationship. This court determined that it was unconstitutional as applied because although anyone in her position, those in same-sex relationships, would benefit from the decision, there were a lot of constitutional applications for those who were in opposite-sex couples, and that was an as-applied challenge. Here, we have contended from the beginning that this is only as applied. And we know, and it's important that in addition to, even if you do determine that it was a facial challenge, the three-judge panel laws and Holdstock and the Cryon case acknowledge that it's only when you raise them within the time requirements of that statute. So, but it's important to know here that this claim does retroactively apply here and violate her constitutional rights. And we know that because of at least 4 Supreme Court cases. Those are Osborne v. Leach, Ryan v. Kmart, Duckworth v. Mule, and the Bollock case that we all cite in our brief. All of those cases say that an accrued claim of action is a property interest and it gets constitutional guarantees and it cannot be retroactively taken by the legislature. Specifically, in the Bollock case, which is a Supreme Court case, it was a very similar issue. There, the plaintiff's personal injury claim accrued or vested before the General Assembly enacted a statute of repose that would have applied under those facts. And the court said that if that statute of repose defense applied retroactively to that vested personal injury claim, it would be unconstitutional in that situation if they allowed it to apply retroactively because the claim had vested. And in that case, it set forth a test that you consider, and that is for whether a law is unconstitutionally retroactive. And the test is, did the act as applied interfere with rights which had vested or liabilities which had accrued at the time it took effect? And it said that an accrued cause of action is a property interest, cannot be retroactively impaired. and here her wrongful death claim accrued upon her death. And I know that the defendants heavily are really they're only attacking our constitutional challenge only on procedural grounds rather than the merits of the constitutional challenge itself. This issue is preserved for appellate review. We know this because the law just says that it must be raised at the trial court level to be preserved for review. And there's a case that's very similar. It's a Supreme Court case from 1985, Tedderton v. Long Manufacturing Company. We cited it in our brief, but it's got very similar procedural issues where the defense raised an affirmative defense, and then they moved for summary judgment. In the response brief, the plaintiffs raised a constitutional challenge, and it was sufficient for the response brief to raise that challenge for the constitutional challenge to be preserved on appeal. It's the same situation here.
So I think your colleagues for the defense would sort of point to the Shannon v. Teston case, and even sort of taking it outside, putting it in the immunity context rather than the constitutional issue context, and suggest that you're still required sort of preemptively, I guess, allege facts that would defeat an immunity defense. Can you, I guess, whether view through the lens of either the constitutional argument or the immunity piece specifically, address those allegations or the need for those allegations in
Yes,
light
Your
of
Honor.
Shannon?
And I can address Shannon v. Teston. There are two distinguishing facts with Shannon v. Teston that I really would like to draw this court's attention to. First is that this is the most important distinction. The court specifically noted that there was not even a conclusory allegation of bad faith in the complaint, and it noted that the facts of that complaint even alleged or even implied good faith conduct in some areas. Another distinction is that the plaintiff didn't challenge whether good faith, which that statute did use the words good faith, they did not challenge that good faith or bad faith, whether they were the same thing. And we are challenging that. But importantly to your point is that's an affirmative defense. We do not have to plead in anticipation of affirmative defenses. For example, anytime we file a negligence claim, I don't anticipate contributory negligence and deny that in my complaints. And it's just not the rule. We cite a case in particular I'd like to draw this court's attention to support that this is an affirmative defense. That is the Delgado v. Petrick case. It deals with a good faith requirement in an immunity context. It is a decision of this court that came down the same day as Shannon v. Teston, which is interesting, but that statute provided immunity for reporting child abuse in good faith, and good faith was even presumed by the express language in that statute. Now, the COVID-19 statute does not presume good faith under the express language. And that court determined that immunity was an affirmative defense, even though the defendants argued that it was something more. And the court denied the motion for summary judgment. The defendants had to meet the statutory requirements of that statute.
And is it, my recollection of Shannon in particular is that in that case, the statute under which the cause of action was being brought, whether, I guess there Dr. Shannon had been given due process in the course of the peer review by the medical board or medical society, that was the statute that actually provided that there should no actions based on good faith. So we're dealing with one statute there. Here, you've got the wrongful death statute, which provides a cause of action, and then a separate statute which would provide the immunity. Am I correct in that thinking?
That's correct. So for a complaint, we just need to allege the wrongful death, what we need to allege for a wrongful death claim, and the immunity, which is separate, is an affirmative defense that it's up for them to show. Our pleadings more than allege, even though we contend that we didn't need to anticipate the immunity defense at all and plead around it, we still did plead allegations that show a lack of good faith. And specifically, I will draw the court's attention to, in particular, very specific ones that are important here.
Let me ask you this. You did move to amend your complaint, which that was denied by the trial court as well, correct?
Yes, Your Honor.
And you had moved to amend to allege of good faith allegation. Is that correct, too?
We had moved to, the defense argued that we had to show bad faith as opposed to not good faith. So we moved to amend to add those allegations if the trial court decided that we needed to show bad faith, to show more than that.
And I didn't look at your transcript, but was there any discussion on why the trial court ruled the way it did on that?
He didn't give a specific reason for why he did, and the trial court order just says the motion to amend is denied.
And that's before us as well, correct?
Yes, Your Honor.
Okay, thank you.
And we have, though, alleged sufficient facts to withstand a 12b6. As this court knows, the facts must be accepted as true. Here, we have alleged that the Treyburn refused to send Ms. Howze to an emergency department, even though her power of attorney, who has the authority to direct all medical decisions, told them repeatedly and instructed them, send her to an emergency department. And in fact, our complaint alleges 5 incidents where Treyburn was instructed to send her to the emergency room, but they declined to do so. We also allege that Treyburn misrepresented the cause of her death in her death certificate as
But that doesn't go to your wrongful death claim, does it?
Well, it goes to showing that they were not acting in good faith and that they cannot use the statute to support dismissal at the Rule 12b6 phase.
Can you explain to me how that, if something they did after your client died, how that can be shown as bad faith in her treatment or their treatment offer?
Well, first, the statute requires that they act in good faith, and they did not do that. But you have to
But
look
I mean,
at...
they have to act in good faith in her treatment. Isn't that what the statute requires?
Yes, Your Honor. I think looking at all of the circumstances, it can show further evidence of how they were acting in bad faith. And I can give some specific examples for what happened leading up to her death. First, Treyburn was giving her an antibiotic that the wound culture showed would be ineffective. They ignored physicians' orders to give her an IV antibiotic, and the physician, when they were delayed of inserting a PICC line, they knew they couldn't give her the antibiotic therapy that she needed, but they still refused to transfer her. And importantly, they refused to transfer her because they have a financial incentive to keep her in the hospital and to make money. And our complaint alleges that the motive for why they did not transfer her was to make money. It wasn't to look at her medical necessity. This is very important because, as the defense argues, that even if we need to show bad faith, that bad faith implies a wrongful motive or dishonest conduct. Well, it's a wrongful motive to refuse to send a patient to an emergency department who was in a very serious emergency situation on the basis of making profit rather than what medically was necessary.
Let me ask you, was there anything in your allegations or in the evidence that showed that COVID had anything to do with your client's death?
The only thing in the allegations that go to COVID having any impact is that the PICC line was delayed. The nurse who was from a different facility was called in to insert a PICC line, and that was delayed. But otherwise, there has been no showing how COVID could have prevented them from sending her to an emergency room. And it's sending to an emergency room that would have saved her life. We know that at this time, this happened in April 2020. COVID had not overrun our hospitals at that time. This is in Durham. It's the heart of medicine for the state. There were a lot of hospitals in the area, so there was no medical reason. And we know this because in order to bring a medical malpractice case in our state, we had to comply with Rule 9J, have this reviewed by a medical expert, and our medical expert says that there was no medical reason not to send her to the emergency room and that they failed to do that, and these actions caused her death.
So is it your argument that the defendant has some burden to show a nexus or relationship under the COVID immunity, or is the COVID immunity just a blanket immunity?
COVID immunity is not a blanket immunity based on the plain language of the statute. The language requires three particular things, and we know it requires all three because it says that they get immunity only if all of the following are met. Those three elements are, first, that the health care is being provided during the pandemic. Second, that their treatment is
Well, let's go through them.
Yes.
Do you agree that's correct based on the retroactivity of the governor's declaration or not?
I'm sorry, I don't understand the question.
The statute became effective on May 4th, correct?
Yes, Your Honor.
Your client had been dead 2 or 3 weeks by that time, correct?
Yes, Your Honor.
And I don't know what your allegation of negligence, if you're alleging even the treatment occurred even before her death, obviously. There was some period of time that led to her death. So I guess what I'm asking you is this a blank check? Or is there some showing of the defendants required to bring their conduct within the declaration?
The defendants are required to show those three elements in order to receive the immunity protection. This is an affirmative defense, and they must show that they are entitled to that.
I'm sort of following up on Judge Tyson's question, I guess, is with respect to the first element that sort of occurred during the pandemic, in shorthand, do you concede that that element is met, or do you contend that there were negligent acts occurring prior to sort of the retroactive effective date, I guess March 10th or so, I guess?
There certainly was negligent acts occurring before March 10th. Of course,
Had the request been made or the orders been written, or what acts of negligence would precede the effective date of the statute?
I think that,
In the light most favorable to you.
yes, Your Honor, she had, as of December, was when the pressure ulcer was first discovered. I think they knew by February how serious the pressure ulcer was, that it was stage 4, meaning it went all the way through the skin to the muscle. And at that point, I think they have to come forward with no showing that they were doing what they should have done during that time. I think you have to look at all of the treatment provided from the moment they saw the pressure ulcer. And what is important is that Lisa Howze, the daughter, had successfully treated pressure ulcers when Miss Howze was in her care at home before she came to Treyburn in the past.
All right, so I guess the summary of my question is this. Do you feel your complaint under a 12B6 standard, like most favorable to you, taking all emphasis true, is sufficient to allege negligence outside of the immunity dates?
I think that
Under the standard?
under the standard, I would have to go back and look at my notes for the facts that we allege on the dates. But
Did you make that argument before the trial court?
no, Your Honor.
That the complaint was sufficient in and of itself for actions of the defendant that occurred prior to the immunity date?
We focused on actions that were occurring in March and April, but there would have been actions in February that are alleged in our complaint from
But
when
the
she-
actions that are, I'm looking at your complaint, and correct me if I'm wrong, but the actions that you were alleging in February is that the facility was understaffed, and that they were written up for being understaffed, and those kinds of things. I haven't yet gotten, I don't see one where you say, this happened in February to my client, other than that, and I may be missing it, but what I'm looking at, it looks like your February allegations are, it's understaffed, they know it's understaffed, they've been told it's understaffed.
Right, so they have chronically, and we allege this in the complaint, that they had been chronically understaffed for at least 3 years prior. I think the evidence will show a long-standing history of chronically being understaffed to a significant amount. What is important in nursing home cases is staffing matters as far as carrying out nurses' orders. And so what was happening before then, and what's important here is that we haven't even been allowed discovery on this claim. So we haven't.
I'm looking at page 39 of the record. if you'll take a look at that, and starting with the allegations, December 171 through 178. I'll give you a moment to get that. If we take, I guess the rest of my question is, if we take this as true, are you contending, even if we were to uphold the immunity, that the complaint was still sufficient based on the allegations and the light most favorable to you?
Yes, Your Honor, they would be, but again, this statute retroactively and unconstitutionally does violate her.
I understand that, but I'm trying to get to an alternative argument that the dismissal would be improper even if the statute applied because the complaint is sufficient to allege malpractice before the effective date of the immunity. That's the argument I'm asking.
I can look at the allegations you raised in rebuttal and bring those up.
Okay.
But I know a lot of our focus has been on the blatant refusals to send her to the.
Right. I read your brief, and I understand that's your primary argument.
But I'm eating into my rebuttal time, so.
Okay.
Thank you.
All right. Thank you. Hear from the appellee. And while you're coming up, I neglected to introduce our clerk and our security officer who's here. The clerk of the court, Mr. Gene Sawyer, is approaching the bench. Thank you, sir. And our security officer today is Mr. Richard Vermilliard, who's over at our doors. So I apologize for overlooking you gentlemen during the original introduction. Okay, we're here from the appellant, and we have, we understand that you had intended to put this on an electronic monitor, and there's some.
That's right, Your Honor.
The wonders of technology, and so we have it before us today.
And those are just statutes that are cited in the briefing, and I provided our friends with a copy of that as well. Your Honors, may it please the court, my name is Chris Smith with the Smith Anderson firm, and I have the privilege to represent the appellees in this matter. Your Honors, I'm going to reverse the order of issues that I was going to address with the court and go right to Senate Bill 704 to start, and then come back to the issue of this being clearly a facial constitutional challenge to the extent this court may think that it was properly raised at any point. Your Honors, with respect to Senate Bill 704, just some brief framing comments.
Before you get that, would you introduce co-counsel as well, please?
Yes, Your Honor. This is my colleague, Mr. Ortiz from Smith Anderson, and also representing the appellees are our friends, Mr. Evans and Ms. Sivan from the Ragsdale Liggett firm.
Thank you.
Thank you, Your Honor. Looking at the statute that's on the top of your packet, Your Honors, that is the immunity legislation that is at issue in this case. That is a complete copy of it that begins at record page 211. And what I think it's important as a table-setting comment for the court is to understand that this is enormously important legislation that impacts nearly 1/5 of the state's economy, and the General Assembly acting unanimously for the state, unanimously, with the governor signing the legislation on the exact same day that it was unanimously passed. The General Assembly acted to provide our healthcare providers, our frontline healthcare providers, who are so needed to help us through what's going on out there, to provide our healthcare providers with the breathing space necessary, and to provide, to give them the breathing space they need to help us through these abnormal times. And the trade-off was that the healthcare system should not be judged during these abnormal times by a liability system created for normal times.
Well, do you agree that the SB, or the COVID immunity statute, I'll call it, is not designed to prevent blanket immunity for healthcare providers during this time? It's really for acts that are related directly or indirectly to the COVID pandemic?
It is meant to be a very broad immunity, Your Honor. It is by no means blanket immunity. It does not protect bad actors, and it does not protect grossly negligent actors.
Well,
That's-
with regard to the sort of the second of the three elements, right? We sort of discussed with your colleagues the sort of the temporal aspect of it, but the second element requires that it's the arrangement or provision of healthcare services is impacted directly or indirectly, basically in response to or as a result of the COVID-19 pandemic in sort of both A and B. So does there not need to be some showing in order to avail yourself of immunity that the negligent acts alleged were in sort of the direct, or that the provision of the healthcare itself was impacted directly or indirectly by the COVID-19 pandemic?
Yes, Your Honor. There does not need to be a showing by the healthcare provider. I think that issue is, that specific issue, the direct or indirect, is not before the court on this issue. That's in fact properly conceded in this case. There are pleadings to that effect. Paragraph 189 as to the directly and indirectly issue. Paragraph 189 says, on April 3, 2020, the unit manager, Colette Lauderdale, indicated in nursing notes the need for appointment with infectious disease, but COVID-19 made it difficult to improbable to get a consult. The healthcare here in this matter, as in the delivery of essentially all healthcare now during the plague, is impacted in some way by the circumstances that are out there. And
how do you get past the allegations of taking the allegations as true at this stage of the previous December, January, February acts that they contend are negligent?
well, Your Honor, that has not, in candor to the court, and I believe our friends on the other side acknowledge that as well, that has not really been the gravamen of this dispute. The gravamen of this dispute has been the failure to make the medical decision to transfer to an emergency room. And Your Honor, if I may provide the court with...
Do you agree, though, at a 12B6, Mr. Smith, at a 12B6 motion, that the complaint is taken as true, allegations, that they are regarded in light most favorable to the non-moving party, the plaintiff? At that point, now, we're not under a 12C or summary judgment. We're looking at this solely on the face of their complaint to decide whether to dismiss or not.
Your Honor, yes, recognizing at the same time that the well-established law of this court and of the Supreme Court is that conclusory allegations are not credited. And Your Honor, if I may suggest that the conclusory allegations of this complaint essentially would, through pleading artifice, drive a massive hole through the unanimous public policy of this state. And if I may just set the table for Your Honors.
Before you go there, I got another question. Do you agree that most legislation, most changes in law are prospective?
Yes, sir, Your Honor.
And if you make a change in the criminal law and you make it retroactive, then that's an ex post facto law. Is that correct?
That's correct, Your Honor.
And even in the civil context, we try to not alter conduct that has already occurred or deprive rights that have already accrued. Is that a fair statement?
That is correct, Your Honor. And
Okay, and would you also agree that the choice of date is totally arbitrary? Why not a week earlier, why not a week later? Particularly when you're going back in time.
Your Honor, I wouldn't say arbitrary. I would say that the governor thoughtfully decided when to declare a public emergency.
And that was on the 4th of May.
That's when Senate Bill 704 was enacted. The governor passed the Executive Order 116 on March the 10th.
March the 10th.
Yes, and Your Honors, what I would suggest is that the General Assembly its authority to regulate and manage our liability system is at its greatest in a crisis like what we have now.
Let me ask you this, but for the immunity statute and the retroactive applicability, do you think your 12B6 motion would have been successful but for that?
No, Your Honor, this is an ordinary negligence claim. Our friends are direct about
Have they
that.
satisfied the pleading requirements? You're not challenging that, are you?
As to stating a claim for ordinary negligence, no, Your Honors. If there had been a claim for, say, punitive damages or the like, we would have argued about that because of the
So your case
conclusory-
does rise or fall upon the applicability of the statute to this complaint? Is that where we are?
At this stage in the litigation, yes, Your Honor. And if I may address the court on Senate Bill 704 and why it is so important that this court, with this statute, that I can promise Your Honors, this is not going to be the last time that this statute is before this court. There are a number of ways that, and we've seen the complaints across the state, where complaints are starting to come in, where they're trying to weave through the syntax of the unanimous public policy of the state. And if I may direct Your Honors to the purpose section of the immunity statute, 131, there are two interpretive bookends that I think should guide the court in its assessment of the breadth of this statute. The first is section 131, the purpose statute, the purpose section. I'll read just the first sentence, which is highlighted there for you. It is the purpose of this article to promote the public health, safety, and welfare of all citizens by broadly protecting the healthcare facilities and healthcare providers in this state from liability that may result from treatment of individuals during the COVID-19 public health emergency. And it goes on with similar language. That's the first bookend. The second bookend, Your Honors, is section 134, the final section of the immunity provision. This article shall be liberally construed to effectuate its public health emergency purpose as outlined in section 131. So those are the interpretive guidelines for this court in addressing this critical piece of legislation.
And it goes on to say that it should be for acts or omissions after March the 10th, 2022, does it not?
Yes, Your Honor, it defines the period to include the 45 days of the emergency order before the legislation was positively passed by the General Assembly.
Yeah, it says the section is effective when it becomes law and applies to acts or omissions occurring during the time of the Executive Order 116 issued on March the 10th. So it doesn't apply to acts or omissions that occurred before March the 10th, does it?
It does not, Your Honor. You are correct. You are correct. And then, Your Honors, to continue the discussion about the breadth of the statute here, turning to really the meat of the coconut, section 133, it's entitled immunity. We all know that the law is that heading is another important interpretive guideline for this court. It's entitled immunity. It is not entitled affirmative defense. Secondly, Your Honors, the language...
How do you assert that?
Pardon me, Your Honor?
That doesn't come by osmosis. Don't you have a duty to assert the immunity? It doesn't rise on its own, does it?
We move to dismiss based upon the immunity.
So
Your Honor.
I understand that, but that was an affirmative act that you had to take to do that in order to bring that to the court's attention.
Indeed, Your Honor, yes. But the notion, I think what the issue here in this case...
And if you had not brought it, you would have waived it.
And certainly committed malpractice, Your Honor, to allow this lawsuit to proceed. And candidly, Your Honor, I think the courts would have a sua sponte responsibility in this sense, may. We haven't briefed that, we haven't looked at that, but it just occurred to me, my gosh, well, if that
But
situation
generally,
arose-
the party that's going to assert a right has a duty to assert it, and in the absence of that, of being asserted, it can be waived. You do agree as a general principle?
That's a generally, yes, Your Honor, that's absolutely right. But if I may.
I mean,
get-
even sovereign immunity can be waived, right?
Yes, sir.
Yeah.
Yes, sir, Your Honor. If I may get to what I think really is the meat of the coconut here.
If we agree with you on everything, the immunity's there, can we still reverse and send the case back based upon the allegations in the complaint prior to March 10th?
Your Honor, speaking as candidly with the court and as an officer of the court, that has not been what this litigation has been about.
But the standard of review that we're looking at the complaint on what the trial court did is a 12B6 standard, which is a standard of leniency to the pleadings.
Indeed, Your Honor. But the gravamen of the lawsuit, while they may have some complaints about pre-Senate Bill 704 conduct, the gravamen of the lawsuit is what happened during the period of the immunity caused Ms. Howze to die sooner than she otherwise would have.
And then that goes to the breadth of whether or not the treatment of the plaintiff was directly related to the COVID response or not, directly or indirectly. And again, that would be your burden there too.
Well, Your Honor, to address the burden issue, and I did attempt in answering Judge Hampson's question that with respect to directly or indirectly, it's not in this case. And the plaintiffs have properly acknowledged that the care was in some fashion impacted by the circumstances of COVID-19. And that, I think, Your Honors, is really a res ipsa loquitur issue, that essentially everything we're doing now is in some way impacted by COVID-19. And we rely upon the governor to decide when this emergency period is over. But if I may, Your Honors, on this issue of affirmative defense, burden, my friend on the other side said the defendants are required to show, to come forward with evidence. That makes no sense with an immunity for two reasons. One, there are the three provisions, during the period of the executive order and the immunity. Two, that it's directly or indirectly related in some way to COVID-19 circumstances. And three, that it is done in good faith. Your Honors, I would direct the court to paragraphs 159 and 160 of the complaint to illustrate for you vividly how it is, just through pleading artifice, statewide, we will be in a situation where lawsuits are filed that drive a massive hole through the unanimous, we have 10.8 million people in this state, unanimous public policy of this state to protect our healthcare providers. And what I would say, Your Honor, is at paragraph 159, there is listed a litany of classic ordinary negligence allegations, 26 of them in a row. And this is just by way of example. There are other ways to illustrate this in the complaint. But then at paragraph 160, it says, the failures as listed above were not providing health care in good faith. That is merely a conclusory allegation, Your Honors. And what the statute clearly is intended to provide is an immunity absent a malevolent heart. Good faith in delivery of health care is generally presumed. It's not in medical malpractice cases ordinarily, as I understand it. But with the magical invocation of that prepositional phrase, upon information and belief or not in good faith, suddenly the complaint is transmogrified into something that can vaporize the unanimous public policy of the state.
Your client, the plaintiff's counsel argued during her presentation to follow the money. And you have anecdotal reports of someone in Chicago shot 35 times and he was killed by COVID. You have reports the state medical director of Pennsylvania had ordered 280 death certificates that listed COVID as a cause of death to be modified. So it's kind of using COVID can cure a lot of ills and can generate a lot of revenue that otherwise wouldn't be there. So I don't think you would want us to advocate that it can be used as a way to distinguish or disguise conduct which otherwise should be actionable, would you?
Absolutely not, Your Honor. And what I would point the court to again in the complaint, and the problem with this case and the pleadings that we're seeing out there attempting to get around the unanimous public policy of this state, by way of example, paragraph 226, and this is upon information and belief, an order was issued by the corporate owners to keep every resident in the facility, no matter what, to maintain census and therefore income. Now that is just simply a conclusory allegation. If there were any evidentiary facts to support it, they would be in the complaint. You can't simply just make an allegation and attach the magic prepositional phrase upon information and belief and leapfrog.
But at 12B6, what are you contending that they should have alleged to survive a 12B6? What bad faith? You're using the phrase bad faith. They're using the phrase good faith. And you're saying they haven't alleged enough. What is it your contention that they should have alleged? And as I read through the argument that you made to the judge, I didn't pick out exactly what you're saying that they should have alleged, that they had to allege to get there, to get this past what you're saying conclusory allegations.
Yes, sir, Your Honor, and I'll answer your question directly, and I think this is consistent with the Shannon case as well, and both the plain language of the statute as well as how we deal with immunities in the Shannon case and cases like it supports this this position. In paragraph 226, taking you back to the exact same one, upon information and belief, an order was issued by the corporate owners to keep every resident in the facility. It says upon information and belief because there's no evidence. They don't have those facts. If paragraph 226 said an order was issued by the corporate owners to keep every resident in the facility, that is not the conduct that Senate Bill 704 is intended to protect. Period, full stop. It does not.
Well, at 12B6, before you've had any discovery, how would you be able to allege that without doing it upon information and belief?
That's the whole point of the immunity, and that is the trade-off in the unanimous public policy of the state. It can't be, and I think Judge Hudson was very receptive to this reality as an experienced trial court judge, that you cannot let a magical prepositional phrase upon information and belief or anything like that, or not in good faith, transmogrify what's supposed to be an immunity into a vehicle for discovery. So the General Assembly, in its
well, let me put it to you this way: if I mean, hypothetically, if a plaintiff had met whatever standard for allegations of health care not provided in good faith required by the statute in their complaint, would you not be contending that there was at least an issue of fact, as going forward to summary judgment as to whether or not your client was acting in good faith?
I think
So my point is,
yes.
there can be a factual question that needs to be decided at some point along in the litigation regarding the application of immunity.
Well, so no, and let me explain, please. So the issue of discovery as to whether there is evidence for the healthcare community that it needs to affirmatively show directly or indirectly related to COVID circumstances, or that it was acting in good faith. This immunity legislation, you would be turning it on its head to say that it creates an additional obligation that's not in any other lawsuit.
Well, your argument right here seems to go against your argument right here seems to see that your argument that this is a blanket immunity and goes against what you said earlier, that no, you've got to meet these requirements in order to do that. Those seem to be antithetical to me in what I'm hearing you say.
If I may explain what I meant by it is not a blanket immunity, it is a broad immunity. And what the General Assembly has seen fit to do unanimously is to put a pause on the ordinary negligence aspect of medical malpractice litigation during this tremendous emergency. Bad actors, people who do really...
Well, and this is sort of unfair to put on you at 6 minutes and left in your argument, I concede. But the statute says it's immunity from civil liability. It's not immunity from suit.
Your Honor...
And there's a difference there, I think.
I believe that there is a difference for lawyers to debate the syntax. We have the General Assembly acting under the time pressures that it acted and anticipating this kind of lawyer argument and invocation of magical prepositional phrases to try and undermine the unanimous policy to protect us and enable the healthcare system to do what we desperately need it to do. The General Assembly labeled it immunity, and they gave us the interpretive bookends in order to give your honors comfort when you see syntax issues like that. That's your interpretive guideline, that this is, as the legislation says, an immunity.
If the allegation in 226 is true, would that conduct take your client's conduct outside of the immunity?
It would not be, that would not be a good faith actor. If it were factual.
Okay, then we go back to the standard again, the standard review. North Carolina has notice pleading requirements on complaints, is that correct?
Yes, Your Honor, that's our general rule. Yes.
With the additional 9J standard that someone has reviewed the standard of care and there's a deviation, correct?
Yes, Your Honor.
So I guess the trouble I'm having here is you may be entirely true. You may be entirely correct. I think, but the point that we're at right now in dismissing the complaint without even an answer, without a 12C or a Rule 56 with affidavits, that under our standard of review and under the concept of notice pleading, they have alleged a fact, if true, that would take your client's conduct outside of the immunity.
No, Your Honor. And please allow me to explain. This is a very important point.
Right.
And I appreciate the court's comments about notice pleading. At the same time, we have well-established law that just speculative pleading, conclusory allegations, legal conclusions are not sufficient, and that the court can disregard those and should, especially in a situation when we're dealing with concerns of pleading artifice. But more importantly, Your Honor, we have recently enacted positive, unanimous law by the General Assembly that provides this court those interpretive bookends with the heading immunity. And, Your Honor, I would suggest to the court that if the court thinks that there is some conflict between our law about we won't yield to conclusory allegations and notice pleading, that debate is firmly resolved in this instance and in these types of lawsuits by the interpretive bookends given this court by 10.8 million people in the state.
Well, I don't want to interrupt your argument, but you've got about 2.5 minutes left, and I want to hear from you about the constitutional challenge and your take on that.
Well, Your Honor, it is not before the court to start. And
Well, that's
this-
why I want you to tell me why it's not before the court and what they didn't do that they should have done.
Well,
make it
this is clearly facial relief that is sought. The claim here is, as Your Honor's question initially suggested, that a ruling here as to the retroactivity period would apply to all negligence claims asserted during that retroactivity period. There's
But an as-applied challenge doesn't necessarily only impact one individual, right? There, I mean, an as-applied challenge can have a broader applicability. The question is, you know, where do you draw that line between a facial
Well,
challenge?
yes, Your Honor, and I would suggest to you that, you know, it is a bit of open field running, and I appreciated Your Honor's question about where you draw that line, because the law is really not particularly, in our state jurisprudence, well developed on the difference between facial and as applied. Our U.S. Supreme Court has very well developed law here, and it says clearly, let's not litigate over labels. Let's look at the relief sought and what that would do. And in this instance, it would be akin to saying that every claim in that 45-day period can go forward because the retroactive period is unconstitutional. Your Honors, the first time there was any mention of issues with our motion to dismiss pending for 4 months was February 5th, 5 days before the hearing before Judge Hudson on February the 10th. There was silence until that point. Your Honors have seen at page 39 of the transcript that the motion to amend such as it was made provisionally, dealt only with allegations of bad faith. It didn't touch on the constitutional issue. And Judge Hudson, he was the remand judge in the Holdstock case. He was the trial court judge there. He's experienced with these issues. And in his proper exercise of his discretion, he didn't see any point in allowing further magical invocation of, you know, bad faith versus upon information and belief. And finally, Your Honors, on the constitutional point, this court's appellate jurisdiction is as prescribed by the General Assembly. That's a constitutional provision. I've handed up the Article 4, Section 12, Subsection 2. The first sentence of General Statute 1-81.1, which I've also handed up to the court, and I think this sentence has not been given full treatment yet by the two panels that have addressed the three-judge panel issue, Holdstock and Crine v. YMCA. That sentence says at A1...
We just got that one yesterday, so we're working on that one.
Okay.
Thank you.
All right. Well, venue lies exclusively within Wake County Superior Court with regard to any claim seeking an order or judgment of a court, either final or interlocutory, to restrain the enforcement, operation, or execution of an act of the General Assembly in whole or in part, based upon an allegation that the General Assembly was facially invalid. Your Honors, that also brings us up to Holdstock, which says clearly that only a three-judge panel can initially declare a statute unconstitutional. That's clear from this court's rulings.
But it's also clear, too, that on an as-applied challenge, that single trial judge makes the determination of a reference on facial challenges after the fact.
Well, Your Honor, I would suggest that, again, respectfully to the court, that this, and the court has acknowledged that the three-judge panel law, it is not a beautiful symphony of statutes that hangs together perfectly. It takes some working through, and my suggestion would be that the YMCA case, in speaking on that issue, on an issue it didn't have to address, the plaintiffs and the defendants are not the masters of labels. It's the court. It's the court. And
I'll give you a moment to sum up if you'd like to, and ask what you'd have the court to do.
I would sum up by saying that we must remember that this is enormously important public policy that is square on before this court. And if we allow the magical invocation of prepositional phrases and pleading artifice to vaporize the unanimous public policy of 10.8 million people, it's a problem. And I urge caution. And I would suggest to the court that Judge Hudson, in his trial court experience, knew what to do with this case. He handled it properly. It should be dismissed as barred by Senate Bill 704.
Thank you. Thank you, sir.
Thank you, Your Honors.
Rebuttal?
Your Honor, to address the public policy argument, the public policy is to help with citizens of the state. Citizens are being harmed by the blanket immunity that is being argued by the defendants. This is an affirmative defense that they must prove, and to say that a complaint that alleges facts that go to lack of good faith is barred from a 12b6 with no discovery is against the public policy of the state, and it causes real harm to citizens who are in nursing homes, especially ones where it has a history of bad actions.
But upon information and belief, which seems to be the phrase that your colleague is pointing to as to what defeats, don't you have to, if you've got an immunity statute, don't you have to have more than just upon information and belief in order to get past the immunity?
Well, under Rule 12b6, all allegations are accepted as true. Now, we have pled more than even just the paragraph 226 that goes to support where that is coming from, although I don't think the standard needs that. But elective surgeries at this point had stopped for Treyburn was not getting new admissions. They were losing income at the time. And in fact, this isn't in our pleading, but it's going to go to the evidence. And again, we should have been allowed to get to the evidence. They were billing for physical therapy for Ms. Howze up till the day that she died or the day before she died.
But that's not before us.
It's not, but it just goes to the fact that we have pled sufficient facts to show a lack of good faith, the financial incentive, the order that they gave to maintain census, and the allegations that the reason that they did not transfer her to an emergency room, which would have saved their life, notwithstanding they knew they could not provide her the antibiotic care she needed, was because of a financial decision. And I'd also like to add that bad faith kind of goes to intentional conduct. They refused the power of attorney's instructions, which I argue is an intentional refusal to do something. That amounts to bad faith. The power of attorney has legal authority over the care she's getting, and they, on multiple instances, refuse that. Those are all alleged complaints.
Now, let's back up here just a minute. You said that the power of attorney can what if she had ordered that she be given Enrovectin and they didn't do it and she died? Would that have been bad faith? Because something that's not required by what the healthcare professionals don't believe. It's not whatever your healthcare power of attorney says that you're entitled to that makes it bad faith if they don't do it if there's not a medical reason, is there?
Your Honor, respectfully, for this case, though.
Well, but I'm going to your broad statement that you made, and I'm trying to narrow it down to see exactly what you're saying.
Well, I certainly don't think that if a power of attorney instructed a healthcare provider to do something that clearly causes harm to them, that I understand that. But here we have a 9-day expert who's saying that certifying that had they sent her to the emergency department as her power of attorney instructed, she wouldn't have died the way and how that she did. And I'd also just like to, I know, Judge Tyson, you were asking questions about the actions that were occurring pre-March 10th. I'm concerned by that because if you only allow her for relief that occurred, for actions that occurred before March 10th, then you're basically wiping out all the really bad stuff that happened during the retroactive portion.
I understand that, but you know, I'm not trying the case here. I'm not even on summary judgment. I'm reviewing a 12b6 order, and so, you know, all that may come later based upon the applicability of the statute. I'm just trying to see if Judge Hudson's order on a 12b6 motion was proper. That's what I'm looking at and nothing more.
Okay.
And I think the question there also becomes, medical malpractice, we run into these issues of like a continuing course of treatment, right? It's not always just, the surgery was done on the wrong leg in one instance in time. And I think your allegations seem to go to more of a course of treatment issue. And I think, our questions are sort of designed to try and flesh out, like, temporally, where are these allegations falling and how do they connect in and around that March 10th date? So I think that's part of where our questioning is coming from on that, just trying to figure out where these allegations fall and what the impact of a continuing course of treatment has on this immunity statute.
Thank you, and that is where, in particular, that's a good analogy on your question about the facial versus as applied. So we're only as applied to this case because there's a lot of questions that get raised for other facts. So what about someone who's admitted and maybe during the period of retroactivity there were actions that were harming them, but they die May 5th? How does that apply to them?
Let's use the example of someone who wanted to someone who wanted to be admitted to a nursing home, senior care facility, and couldn't get in because of the shutdown, and then they died. That's a different situation than what we have here with someone who is inpatient, who's receiving care, and dies before legislation that retroactively applies to a month before she died. That's a different situation as applied to facial. I could raise a facial challenge that I wanted to get in the emergency, I wanted to get into nursing home, I couldn't get in because of COVID. But I guess the situation here is different when you have someone who was there. Your client was there. Your client died before the legislation took place, and that legislation is being backdated to 2 or 3 weeks before your client died. So I guess that's the difference on an as-applied challenge and a facial challenge.
I think the difference is large part also if you look at the actual statute itself. There are different classes of people, even in the provision that deals with the time period. And even if you only look at let's say you just look at just the portion of the statute that goes back to the March 10th order, there would still potentially be claims who maybe don't still receive the same retroactive constitutional claims that we do, depending on when their causes of action vested. That's why it is as applied here. And again, even if this were a facial challenge, hold stock and those line of cases don't prevent the constitutional challenge from being heard by this court. They don't go to that.
Provided it was raised below.
Yes, Your Honor, provided it was raised in the trial court. Again, it was.
I'll give you a moment to sum up and ask what relief you'd had the court to give you.
Yes, we are asking for a ruling that this law is unconstitutional as applied here. However, if you decide to send this back to be heard by a 3-judge panel because you determine it's facial, we still ask for a ruling that we had stated enough for Rule 12b-6, motion to dismiss, in the event the 3-judge panel determines that this is constitutional.
Okay. Thank you. Thank you. Thank you, counsel, for your good arguments. We will adjourn, or we will take a recess.
Adjourn.
Okay, we'll adjourn this session, and then you reconvene, right?
Yes, sir.
All right. Okay, Mr. Sawyer, if you'll adjourn court.
All rise.
Sorry about that.
This session of the North Carolina Court of Appeals is adjourned. And there will be a slight delay as we change out panels. Thank you.